Good morning, everyone. We're going to go ahead and get started. This is the state all-purpose calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams, and at this calendar today, we will address a variety of matters. Have all defense attorneys had the opportunity to interview their clients?
Your Honor, we have a few pleas that are ready, and there's a few that we need to speak. And Judge, I apologize. In my rush, I left my jacket in my car. So
That's okay. The phone is going in and out, Mr. Dot. I can hear, what was the last thing you said? We had some pleas that are ready, and then what was the other thing that you said?
we have pleas that are ready. We still have some folks to talk to, and finally, I forgot my jacket in the car.
Oh, okay. All right. Who do we have first?
So when I get off the highway, that's what I'm doing. Off the highway.
Okay. Judge, I think this is position number 1 and 2, 3. I think Mr. White needs to speak to him.
Okay, Mr. Abdul Rabbani, is that him?
That's correct, Judge. I do need to speak with him.
Okay, is there a phone number Mr. White can call? I'm
Got
sorry, you got it? Okay. Is there another plea we can take while Mr. White does that?
Hold on, Your Honor, I'm sorry, I apologize. Don't forget my friend.
Yeah, no, it's gonna be. There was a mix.
You're done, call me on the radio, in the courtroom. Yeah. Position number 27, Cartier Jenkins.
Okay. Mr. Jenkins, your case is 25 CR 002694E. You're charged with 2 counts of obstruction and 1 count of possession of marijuana less than an ounce. Do you understand your rights today? Oh, I'm sorry, I haven't told you your rights. You have an absolute right to remain silent. All defendants, please pay attention. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. As you can see, I am conducting this hearing over the internet. It's being broadcast as a live stream. It's also being recorded. That means any member of the public can log on and watch. Do you understand your rights and how I'm conducting the hearing today? Is that a yes? All right, thank you so much. All right, Ms. Harrison, can I please have the state's recommendation?
Yes, Your Honor. Good morning.
Good morning.
The state's recommendation in the state of Georgia versus Cartier Jenkins, case number 25CR002694E, is count 1, willful obstruction, time served, 56 days credit for time. I'm sorry. Time served 56 days, credit for time served 28 days. Defendant has been incarcerated since May 31st. Count 2 is willful obstruction of law enforcement. It'll be served 56 days, credit for time served 28 days. The defendant has been incarcerated since May 31st. In possession of marijuana less than 1 ounce. Count 3 will be served 56 days, credit for time served 28 days, and the defendant has been incarcerated since May 31st.
So this is just time served, no additional requirements.
That's correct, Your Honor.
Okay.
And we'd ask that the defendant stipulate to venue, ID, and facts of the case. That'll be all for the state, Your Honor.
All right, so do you so stipulate and do you wish to move forward with taking the plea today, counsel?
I'm sorry, Your Honor.
Do you so stipulate to factual basis ID, venue, and was that your understanding of the offer that it would just be time served and we're gonna have your client move forward taking the plea?
Yes, Judge, that is correct.
All right. Mr. Jenkins, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, thank you. I do need you to speak as loudly as you possibly can, okay? Are you under the influence of any drug? You can put your hand down. Thank you so much for raising it for me. Are you under the influence of any drugs or alcohol at this time?
No,
Is that
ma'am.
enough? Yes, thank you. Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
You understand you're giving up your right to trial by judge or by jury,
Yes, ma'am.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt? And you understand that taking a guilty plea can affect other aspects of your life, such as other open cases, probation, immigration, other things that I may not be aware of or be able to anticipate. Do you understand that? All right, as to the charges previously listed, Mr. Jenkins, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
Not from defense.
No, Your
All
Honor.
right. All right. Best of luck to you, Mr. Jenkins. We don't see you back here. Take care. Have a good day. What do we have next?
Number 34, McCoy. McCoy.
And I'll just-
Okay, I have that this is a negotiated plea as well. Is
Yes,
that correct? All right, Mr. McCoy, your case is 25 CR 002703Y. You are charged with obstruction in this case. Do you understand your rights this morning?
She's talking to you.
You understand your rights?
Yes, ma'am.
All right, thank you. All right, Ms. Harrison, please proceed.
Yes, Your Honor. The state's recommendation in this case, willful obstruction against law enforcement, case number 25CR 002703Y, is time served 54 days with credit for time served 27 days. The defendant was incarcerated on May 15th, 2025. We asked the defendant stipulate to venue, ID, and facts of the case. That'll be all for the state, Your Honor.
All right, do you so stipulate?
that stipulates.
All right, and your client wishes to move forward and take the plea today.
Yes, ma'am. I'll take the plea if this is not affecting my parole status.
Oh, I can't, you need to speak to your attorney about that. All right?
Donna, we still get.
Yes, and he wishes to move forward. All right, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking the plea?
No.
And you're satisfied with your attorney's representation?
I haven't even seen a discovery on an issue, but like I say, if nothing affects my parole status.
Wait, no. So do you want to take, pleas are voluntary. You don't have to take a plea today. Do you wish to take a plea? Is anyone forcing you to do this? If you feel like this is not what you want to do, we don't have to do this today.
Okay, Mr. McCoy does not want to take it today.
Okay, so will you waive arraignment, counsel, and reset further notice for trial?
Yes, we will.
All right, do you wish to be heard on bond?
Yes, Your Honor, if I can have just 1 minute.
Okay. Who's here from pretrial since we're doing bond? Is it Miss Washington, I think I saw earlier?
Yes, Your Honor, I'm here.
Miss, can I have this defendant's, history position 34?
Yes. There are 5 arrest cycles out of Louisiana, including a 2022 felony conviction for possession of cocaine. There are 4 arrest cycles out of Texas, including a possession of marijuana case from 2008. There are 9 arrest cycles from Ohio. That is outside of the 10-year period, including an assault case and a drug abuse case from the 90s. There are 7 arrest cycles out of Georgia, the last arrest being from May of this year for parole violation. There's also an arrest in March of this year for a DUI out of Paulding County. No disposition was listed. There was a 2016 misdemeanor conviction for pointing and aiming a gun in Fulton County and theft by taking. An FTA from 2016.
That's
A-
good. That's good.
Okay.
Thank you, Ms. Washington.
Thank you.
All right. Are we still going forward hearing a bond hearing this morning?
Yes, Judge, we are ready. Thank you for holding for us.
All right, no problem. Ms. Harrison?
Yes, Your Honor. This incident occurred on May 15, 2025. Officers responded to a dispute call I'm sorry. Yeah, 2789 Allegro Drive Northwest. They actually were there to serve a Fulton County temporary protection order on the defendant. Before they attempted to serve the order, they spoke with the victim here, Miss Letitia Michael, over the phone, and she informed the officers that the defendant was at home and he was standing outside her home, and she felt scared for his safety. She mentioned that she did believe the defendant had an active warrant and that there were firearms in the home. Officers checked the defendant's name through the sheriff dispatch and discovered that he was wanted by the State Board of Parole and Pardons for a parole violation related to a weapons offense. Officers did find him in the backyard of the house. They proceeded to the backyard while Ms. Michael stayed at the front with other officers and found the defendant wearing a black t-shirt, blue jeans, and matching the description that Ms. Michael gave. Officers gave the defendant verbal commands to get on the ground and lie down, and just cautioned that he may have entered the home and retrieved a weapon from the backyard, is what officers thought. The defendant attempted to run away from officers on foot, and a foot chase ensued. He ran up a hill. Officers had to catch him by deploying their taser. Once they were able to detain the defendant, he was then transported to Fulton County Jail. Your Honor, we see that this defendant had a previous bond set of $2,000 or $2,000 surety bond set by Judge Mincy. At this time, the state is going to ask that the court uphold that bond. We are aware that the defendant is being held currently on a parole hold with no bond. But the state's recommendation is the $2,000 surety bond that was instated by Judge Mincy, Your Honor. And
Okay.
it also included no further contact with Ms. Letitia Michael and a stay away from 2789 Allegro Drive Northwest. No drugs, weapons, or alcohol or guns while on bond.
Okay. All right, counsel.
Thank you, Your Honor. Mr. McCoy is 51 years old. He has been residing here in Atlanta for the past 20 years. He was previously residing at the incident location 2789 Allegro Drive with his wife of 15 years, but he does have an alternate address that he can stay at 2499 Baxter Drive that belongs to his mother. If Your Honor does not wish for Mr. McCoy to return to Allegro Drive, at least while the case is open. Your Honor, he is currently enrolled at Fortis College in Smyrna, Georgia, studying to be an HVAC technician. Graduate and complete that course in October of this year. Your Honor, he's also a father to 3 teenage children that he does provide for financially, emotionally, and otherwise. He is their one of their primary caregivers along with their mother, Your Honor. And at this time, Mr. McCoy does have that parole violation and a $2,000 bond presently on this case before the court today. But we would ask for Mr. McCoy at this time to receive a signature bond, as he is indigent, represented by the public defender, and can only afford a nominal bond at this time.
Okay, I'll reduce his bond to $1,000 surety with the conditions already set by Judge Mincy. All right, is there anything additional?
Nothing further from defense.
All right, best of luck to you, sir. That will conclude the case for today. Your attorney is gonna do some additional work. All right, who do we have next?
Position 1 through 3.
And Mr. White, what's the announcement?
Chat that he's going to be reset and not needed for court today. We're going to bring him
Okay.
back 26th.
Okay.
Reset 626 SAP.
Correct. Thank you, Judge.
All right, so we will see you back in a couple weeks, sir. Your attorney's gonna do some more work on your case, all right?
Next is position number 5, Mr. Beckhouse.
All right, and the announcement for that case I have is a negotiated plea. Is that still correct?
That's correct, Your Honor.
All right, Mr. Beckham, your case is 25 CR 002991E. You're charged with an offense I will not sound at this time. Do you understand your rights this morning? Is that a yes? I just need you to say that as loudly as possible.
Yes, ma'am.
All right, Ms. Falk, please proceed.
Yes, Your Honor. State's recommendation on this case is 12 months served, 32 days, credit for time served, 16 days. That will be from May 26, 2025. Balance probated, 40 hours of community service, and stay away from the Creek Walk connector. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
And do you so stipulate, Mr. White?
We do, Your Honor. We just asked the probation terminator go non-reporting once he completes his community service.
Okay. All right, sir, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury? Is that a yes?
Yes, ma'am.
All right, thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
All right, thank you. Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand you're giving up your right to trial by judge or by jury?
You said that one more time?
You're giving up your right to trial by judge or by jury. There's not gonna be any more court dates about this. You understand that?
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life, such as probation, immigration, employment, or other things your attorney and I may not be able to anticipate?
Yes, ma'am.
All right, as to the charge I did not sound, how do you plead?
I mean guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
No, Your Honor.
No, Your Honor.
All right, best of luck to you, sir. That concludes your case at this time.
Thank you.
All right.
Number 14, Davis.
All right, Mr. Davis, I have the negotiated plea as well. Is that still correct?
Yes, Your Honor. Is it 14 or 15? Because
I had 15. This is Davis, not Daniels, correct?
It's Davis. Yes, Davis.
okay, 15.
15. I'm
Yes.
sorry.
Sorry, no worries.
All right, your case number is 25 CR 002708B. You're charged with theft by taking, loitering, and prowling, criminal trespass, and obstruction. Do you understand your rights today? Mr. Davis, do you understand your rights? I need you to speak as loudly as you can. Okay, I'm gonna assume that's a yes. Ms. Falk?
Yes, Your Honor. On count 1, 12 months served, 90 days, credit for time served, 27 days. That will be from May 15th of 2025. Balance probated. Stay away from Georgia Tech. 40 hours of community service. Anti-theft course. No further contact with Fletcher Machanda, Anirudh Mali, and Benedict Bortuccio. Restitution open for the next 30 days. Count 2 will merge with count 3. Count 3 will be 12 months concurrent with count 1. Stay away from Georgia Tech. And count 4 will be 12 months concurrent with count 1 and a $300 fine. This is a global recommendation with the second case on the calendar, position 16, which is a which is also a theft by taking. And that will be 12 months concurrent with the previous case on count 1, and count 2, 12 months concurrent with count 1. That also occurred at Georgia Tech, also involved bikes and scooters. We do ask that probation not go non-reporting or terminate given the multiple thefts that happened on this property. That's all for this. Oh, we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state, and we would like to sound for Mr. Machada, Mr. Mali, and Mr. Bortuccio if they are here in court.
All right, I'm sorry, I do need to make you aware you did have the second case. Your second case is 25 CR 002718B. And as Ms. Falk indicated, there are 2 counts of theft by taking in that case. Mr. White, you so stipulate?
We do, Your Honor.
All right, and that was your understanding of the agreement?
That's correct, Judge.
All right. I'm sounding for any of the victims at this time as just listed by Ms. Falk. If you are present and wish to make a brief statement, please turn on your cameras, raise your right hands. Okay, seeing none. Sir, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
Thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time? Did anyone force you to take a plea today? Did anyone promise you anything in exchange for taking a plea? And you understand that taking a plea, you're giving up your right to trial in both of these cases by judge or by jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you further understand that taking a guilty plea may affect other aspects of your life, such as employment, probation, immigration, other things I may not be able to anticipate?
Yes.
Do you fully understand the requirements of the sentence as explained to you by your attorney, including the fine you have to pay, the community service you have to complete, and the fact that you may have to pay restitution in the future? All right, as to the charges ending in the case ending in 2708B, how do you plead, Mr. Davis?
Yes.
All right, and as to the charges listed in 2718B, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense at this time?
No, Your Honor.
All right, best of luck to you, Mr. Davis. That concludes your case.
Position 11 and 12, Carolina.
All right, I have that this is a negotiated plea. Is that correct?
That's correct, Judge.
All right, your case, sir, is 23 CR 006376C. You're charged with hit and run. The other case that you have pending is an FTA. Do you understand your rights this morning? Is that a yes? Okay. All right, thank you so much. When you speak, if you don't mind, just say it as loudly as possible. Ms. Falk, please proceed.
Yes, Your Honor. And I would just like to let PD White know, I know that I did ask for restitution to remain open. We did receive from the victim the restitution amount, which I can send you. And if, Your Honor, if we may just have a moment to see if his client agrees with
That's
that, or we're
fine.
going to need a restitution hearing.
Are you talking about the previous case?
No, I'm talking about Guadalupe, Carolina, Caesar Carolina.
I don't have anything about restitution on my offer. It's just says 40 hours community service, $1,000 fine, and a $300 fine. No further contact with Guadalupe or Guadalupe.
That is correct. I put a note in for my victim advocate to determine to get the restitution amount from the victim. So, Your Honor, they have accepted the plea. We're ready to proceed. The state's recommendation on this is 12 months served 52 days, credit for time served 26 days from October 6th to October 19th of 2023, May 30th, 2025 to today, balance probated, 40 hours of community service, a $1,000 fine, no further contact with Guadalupe Mendoza, and a $300. That's what happened. It was supposed to be a $1,000 in restitution. So there was an error on my part, and that is what the victim tendered to us. So instead of a $1,000 fine, it's $1,000 in restitution and a $300 fine. Is that acceptable? for the
That's fair.
defense?
Fair
Okay.
enough. That makes
Thank
sense.
you.
Okay, that doesn't really change the substance of
It
what he's
does not.
declaring to, so I think that's okay.
And we do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. That's all for the state.
So stipulated, Judge.
All right,
We-
thank you. Go ahead, I'm sorry, go ahead, Mr. White.
Sorry, we would ask that once he completes paying that the probation terminate.
State has
Okay.
no objection.
And once he makes that payment, it can terminate. All right, sir, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
No.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time? Did anyone promise you anything in exchange for taking a guilty plea today?
No.
Did anyone promise, are you satisfied with your attorney's representation? And do you fully understand the requirements of the sentence, including the fines and restitution you have to pay?
No.
And you understand that you're giving up your right today to go to trial by judge or jury and have the state prove these charges against you beyond a reasonable doubt? As to the charge of hit and run, how do you plead?
Good.
I accept your guilty plea. Is there anything additional from the state or defense?
No.
Yes, Your Honor. It appears Miss Mendoza is here. I don't know if there's anything she would like to add.
Very briefly, Ms. Mendoza, if you'd like to make a very brief statement, please raise your right hand, turn on your camera.
No, I don't have anything to say.
All right, thank you. All right, best of luck to you, sir. That concludes your case.
Thank you, Your Honor.
All right, who do we have next?
Position 14, Daniels.
And this one I have is negotiated plea as well.
Correct, Judge.
All right. Good morning, sir. Your case is 25 CR 003012E. You are charged with theft by shoplifting and criminal trespass. Do you understand, right? All right, thank you. I'm gonna believe that you said yes. Ms. Falk, please proceed.
Yes, Your Honor. On position number 14, the state's recommendation for the offense of theft by shoplifting is going to be 12 months served, 30 days, credit for time served 15 days from May 27th of 2025. Balance probated, 40 hours of community service, an anti-theft course. Stay away from the Exxon located at 1917 Prior Road in Atlanta. And count 2, the criminal trespass is 12 months concurrent with count 1. We have no issue with him going non-reporting after the community service, but do object to a termination since this is a location he was trespassed from previously and has been previously given balance suspended on a
What was the name? What location is it again, Ms. Falk? What is it?
Exxon at 1917 Prior Road, Northwest in Atlanta.
Okay. And do you stipulate to those elements, and that was your understanding of the agreement?
Yes, Your Honor.
All right. Sir, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge? Is that a yes? All right, thank you. To say it as loudly as you can so we can pick it up. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, I'm not.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange?
No.
You understand that taking a plea, you're giving up your right to trial by judge or by jury?
Yes, I do.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you further understand the requirements, including the fact that you cannot go back to that gas station and you also need to complete some community service?
Yes.
And you're fully satisfied with your attorney's representation today?
Yes, I am.
All right, as to the charges listed in the case ending in 3012E, how do you plead, Mr. Daniels?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
Nothing, Your Honor.
Nothing from the defense, Judge.
All right, best of luck to you. I see a message in the chat from Attorney Remsen. Ms. Falk, if that's your case, perhaps you can send the offer over. All right, who do we have next?
Position 41 and 42, Skinner.
I have that this is a negotiated plea as well.
Yes, Judge, that's correct.
All right, thank you. Mrs. Skinner, you have two cases, 24 CR 005031C and 25 CR 003019C. In the first case, you're charged with criminal trespass and damage to property. In the second case, you're charged with battery, family violence, and simple battery. Do you understand your rights today?
Yes, Your Honor.
All right, Ms. Harrison?
Yes, Your Honor. The state's recommendation in the first case, the state of Georgia versus Jerry Skinner, 24 CR 005031C. The criminal trespass and damage to property is 12 months probation, served 34 days, credit for time served 17 days. The defendant has been incarcerated since May 24th of 2025. The balance will be probated. A stay away from 140 Pine Street Northeast. No further contact at all with Jasmine Lloyd. Restitution to the victim, we'll leave that open for 30 days for the amount, and completion of a family violence intervention program. This is a global recommendation with case 25CR003019C, which is battery, family violence, and simple battery. The state's recommendation on that case, count one, the battery, family violence is 12 months, served 86 days, credit for time served 15 days. Defendant has been incarcerated since May 27th. The balance will be probated. Completion of a family violence intervention program, 40 hours of community service, no contact at all with Jasmine Lloyd, a stay away from 1856 Wells Drive, Southwest, apartment 508. No firearms, and count two will merge with count one. We ask that the defendant stipulate to venue, ID, and facts of the case. And we'll sound for Ms. Lloyd in case she joined us in court today. That'll be all for the state, Your Honor.
All right, was that your understanding of the offer? And how many additional days does the defendant have to serve in Fulton County Jail?
Give me 1 second. Let me count that.
I'm never good at that. Let me see. And your client understands this is not a time served plea. He would have additional time if if he takes the plea today. Is that a yes? The client does understand that and wishes to take this plea.
He on four sides. Okay, okay. I got you. The call county got done.
Yes.
And Your Honor, I believe it's about 35-ish odd days.
Okay, is it that many? Okay, so your client has additional time to serve. Does he want to take the plea today? In the meantime, I'm sounding for Ms. Lloyd. Ms. Lloyd, if you're present and wish to make a statement, this is your opportunity. Okay, she's not present. Are we moving forward taking the plea?
Yes, Judge.
All right. Please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, Your Honor.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
Oh, Your Honor.
Did anyone promise you anything in exchange for taking a plea?
Oh, Your Honor.
Did anyone force you to take a plea today?
Oh, Your Honor.
And you understand you're giving up your right to trial by judge or jury?
Yes, Your Honor.
And you understand you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, Your Honor.
And you understand the requirements, including the fact that you have to take classes. You cannot go back to either of those locations. You're to have no contact with Ms. Wells. You're also going to complete community service, and you do have additional time today to serve in the Fulton County Jail, which we estimated about additional 30 days. Do you understand that?
Yes, Your Honor.
All right, as to the charges listed in case 5031C, ending with the end of 5031C, how do you plead?
Guilty.
And as to the charges listed in the case ending in 3091C, how do you plead, Mr. Skinner?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
Not from defense.
No, Your Honor.
All right, best of luck to you, sir. That concludes your case.
40, position 43 and 44, Mr. Demetrius Taylor.
I'm sorry, position 44?
Position 43 and 44.
Okay, thank you. I'm sorry, I couldn't hear. It went out for a minute. All right, Mr. Taylor, your case is 21 CR 005297J. You're charged with simple battery, family violence, and you also have an FTA today. You understand your rights?
Ma'am.
All right, Ms. Harrison?
Yes, Your Honor. The state of Georgia versus Demetrius Taylor, case number 21CR 005297J, simple battery, family violence. The state's recommendation is 12 months probation, served 40 days, credit for time served 20 days. The defendant was incarcerated October 6, 2021 to October 13th, and then again on the FTA pickup on May 30th. The balance will be probated. We're asking for completion of a family violence intervention program, 40 hours of community service, no contact at all with Alfreda Laster, a stay away from 540 Humphrey Street Southwest, apartment 2222, and no firearms. And for the position 44, the failure to appear, the state will enter a null process upon plea to the underlying offense. We're asking for the defendant to stipulate to venue, ID, and facts of the case, and we'll sound for Ms. Laster in case she's joined us in court today, and that'll be all for the state.
All right, is Ms. Laster present? And Ms. just make a brief statement? All right, hearing none, do you so stipulate to those three elements, and that was your understanding of the agreement?
Yes, Your Honor, defense stipulates.
All right, thank you. I'm going to ask you some questions, sir, to make sure this plea is voluntary. Please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Did anyone force you to take a plea today?
No, ma'am.
All right, and are you under the influence of any drugs or alcohol at this time?
No, ma'am.
You understand that taking a guilty plea, you're giving up your right to trial by judge or by jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you further understand the requirements of the sentence, including the class that you have to take? And have the requirements been fully explained to you by your attorney?
Yes.
And you understand that taking a guilty plea may affect other aspects of your life, such as employment, probation, immigration, or other things I may not be able to anticipate?
Yes.
As to the charge of simple battery, family violence, how do you plead, Mr. Taylor?
Yes.
I accept your guilty plea. Is there anything additional from the state or from the defense?
No, Your Honor.
No, Your Honor.
All right, best of luck to you, sir. That concludes your case. Who do we have next?
Position number 35, Mr. McCray.
All right, Mr. McCray, your case is 25 CR 002706J. You're charged with obstruction, 2 counts, fare evasion, and doing some prohibited acts in a rail or bus station. You understand your rights?
Your Honor, I'm not sure if this one was negotiated. I had a note that they needed to speak.
Yes, Your Honor, we needed time to speak, like not just 1 minute with Mr. McCray.
Okay, and I'm sorry, you say you still need that time, or you've done it and have an announcement?
I need that time right now. If we can have just 1 minute, Your Honor, should not.
Okay, that's fine.
You want to switch?
Is there another case we could take very briefly?
We can do position number add on 1 and 2, Mr. Thomas, Anthony Thomas.
All right, I have need to speak with that one as well. Do we have an announcement for that case?
Judge, I sent an email to Ms. Falk. I just need a couple minutes to hear back whether it's going to be negotiated plea or non-negotiated plea, Judge.
Okay, we'll take a few minutes.
How about that? ACDC?
No. We could do Ray Love. position number 31. Come on, Ray.
And after Mr. Love, we'll probably take a quick 5-minute break. Have to get some water. Mr. Love, your case is 25 CR 002943A. You're charged with obstruction in this case. You understand your rights?
All right, it looks like we need to speak to Mr. Love, Judge.
Okay. We're gonna take a very brief 5-minute break unless there is another case we can take right away. It doesn't look like it. All right, we'll be on a very, very brief hold. Oh, I'm sorry. Are we ready for this case?
We are ready for Mr. McCray. If we can ask the state for an amendment to the offer.
Okay, so do you need to speak with the, it sounds like we're not quite ready.
No, we're not quite ready to speak.
Okay, we're gonna take a 5-minute break. I'll let you all speak and I'll be right back.
Ms. Harrison or Ms. Falk for McCray 35.
Mhm.
But I believe the offer was 12 months probation.
You went on mute. I'm sorry. I don't know if you're controlling it.
Oh, sorry. Yeah, so the offer we had was 12 months probation, 52 days to serve, 26 days credit for time served, balance probated, and then $300 fine. That's correct?
Yes, that's correct.
And so for Mr. McCray, and also merge count 2 with count 1, merge count 4 with count 1, count 3, 12 months probation concurrent, stay away from all MARTA property.
Right.
So for Mr. McCray, he's an employee working at Georgia Tech and he uses the MARTA to get there. If we could have a stay away just from the North Avenue MARTA station, which was the incident location, he can still use the train to get to work. He'll get off at Midtown and just walk from there.
Okay.
If that's amenable to the state. And then also we would ask if probation can terminate upon payment of the fine.
Okay. I believe the stay away should be okay, but I want to check one thing before we agree to that. And I don't think we have any objection to probation. So give me just one.
Amen. You, sir.
Okay, we would be agreeable to the stay away from the North Avenue, MARTA bus station, the MARTA location there. But we'll also ask that the defendant comply with any active MARTA suspensions. I didn't see any in this quick search, but if there are any other MARTA suspensions, we'll ask that the defendant comply with that, so he'll be able to transport back and forth to work.
Yeah, we agree. There's no problem with that.
All right, are we ready to proceed?
Yes, Your Honor.
All right, what position? We're back to position 35.
That's correct.
All right, and the announcement is?
We are accepting the plea with the new terms that we defense and state have just agreed to.
All right, so it's a negotiated plea. All right, Mr. McCray, I already asked if you understood your rights, so let's go to Ms. Harrison. What is the state's recommendation currently?
Yes, Your Honor. The state's recommendation in this case for count 1 is willful obstruction of law enforcement officers. The state's recommendation is 12 months probation, served 52 days, credit for time served 26 days. The defendant has been incarcerated since May 16th. The balance will be probated, and there's a $300 fine. Count 2, willful obstruction of law enforcement officers, will merge with count 1. Count 3, fare evasion, will be a 12-month probation concurrent with count 1. We'll do a stay away from the North Avenue MARTA station and ask that the defendant comply with all active or any and all active MARTA suspensions. Count 4, prohibition of certain acts at bus or rail station, will be a 12-month probation concurrent with count 1. We ask that the defendant stipulate to venue, ID, and facts of the case, and that'll be all for the state, Your Honor.
All right, do you so stipulate, and that was your understanding?
Our understanding also was that probation was to terminate upon payment of the fine.
And we have no objection to that, Your Honor.
Okay. All right, Mr. McCray, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that by taking a guilty plea, you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand that by accepting a guilty plea, it may affect other aspects of your life, such as immigration, probation, employment, or other things I cannot anticipate?
Yes, ma'am.
And you further understand the requirements, including the fines that you have to pay?
Yes, ma'am.
All right, as to the charges listed previously, Mr. McCray, how do you plead?
Guilty.
I accept your guilty plea. Please also be aware that you must comply with any active MARTA suspensions and stay away from that MARTA location. All right, they don't want you there.
Yes, ma'am. Thank you, Mr.
All right, best of luck to you, sir. That concludes your case at this time.
Position number 21 and 22, Mr. Hale.
Okay, I know that one was being pre-tried. Is there any announcement for that one?
He has a private attorney already logged on.
Yeah, he's online. Mr. Remsen, is there an announcement?
I'm working that out with the state now, Your Honor.
Okay, so we're not ready for that one. Can we have another position, please?
Yeah, we can do number. We can do Mr. Love, position number 31.
All right, Mr. Haddad, we ready for Mr. Love?
We're ready, Judge.
Okay.
So you'll be getting out tomorrow, okay? I don't know, from DeKalb County.
What is the charge?
I have no.
All right, Mr. Love, your case again, 25 CR 00294E. I'm sorry, 2943A. You're charged with obstruction. Do you understand your rights? All right. And what's the announcement is?
We're ready for a plea, Judge. We'll be negotiating plea, Judge.
All right, thank you. Ms. Harrison?
Yes, Your Honor. In the state of Georgia versus Ray Love, case 25 CR 0029438, willful obstruction of law enforcement, the state's recommendation is 12 months probation, served 38 days, Credit for time served 19 days. The defendant has been incarcerated since May 23rd. The balance will be probated. We're asking for 40 hours of community service to be completed, a $300 fine, stay away from racetrack located at 3510 Camp Creek Parkway, East Point, and we ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea, and that'll be all for the state, Your Honor.
All right, and that was your understanding, and do you so stipulate?
Yes, Judge.
All right, thank you. Mr. Love, please raise your right hand. Do you swear or affirm testimony you give today be the truth to the best of your knowledge? Thank you. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today? Did anyone promise you anything in exchange for taking a plea?
Oh.
You understand by taking a guilty plea, you're giving up your right to trial by judge or by jury.
All right.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
All right.
Is that a yes?
Yes.
All right, thank you. And you further understand that taking a guilty plea may affect other aspects of your life, such as employment, probation, immigration, or things I cannot anticipate.
Guilty plea? Yes.
And you wish to move forward and take a plea today?
Guilty.
No, I said you wish to move forward and take a plea today?
On the Republic today. So, yeah.
Okay, and you fully understand the requirements, including the fine that you have to pay, the community service, and the fact that you need to stay away from that racetrack?
Yes, I know.
All right. As to the charge of obstruction, how do you plead, Mr. Love?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
Judge, I would ask the court to consider non-reporting upon completion of the terms.
All right, he can go. I don't have any objection to that. He can go non-reporting. Does the state wish to lodge any objection to that?
The state has no objection, Your Honor.
Okay. Best of luck to you, Mr. Love. That concludes your case.
Judge Williams,
Yes.
it's attorney Scott Fortis here. How
Oh,
you
good
doing?
morning, Mr. Fortis. How are you? Who's your client?
Samuel Morgan.
Okay, is there an announcement that you wish to pre-try this case with the state?
I haven't had an opportunity to pre-try it. However, I don't think my client's going to be inclined to accept anything at this point. So
Okay.
I would ask the case to kind of move along.
All right, if you would enter a waiver of arraignment, we'll go ahead and get the case reset for trial and assigned to the division.
Because it looks like that was filed back in June. Is this on accusation 23 CR 002875?
Yes.
Or is this a different
But I think
accusation?
no, that's the same case, but I think he is also being held on an FTA, which is why he ended up on this calendar today.
So that was done in error, Judge. We filed back in January of 2023 the waiver of arraignment. I went down to the clerk's office and corrected all that, and they did have that on file. And for whatever reason, I think on May 15th they issued a failure to appear, even though we had the waiver that was filed back in January, I think, of 2023.
Did he miss something else? Ms. Champion, are you able to see what happened with the FTA?
Yes.
Oh, we're gonna take a quick 5-minute hold while Ms. Champion looks at that for me.
Can we do position number 33 while we wait, Mr. Matthews?
All right, my apologies. Did we see anything about that, Ms. Champion?
The FTA was set aside on June 4th. He's also being held in the jail on a parole hold.
Okay, so this case is not holding him. Okay,
That's
Mr.
correct.
Fortis. All right, so it sounds like there's nothing to be done on this matter today.
Thank you, Judge. Good to see you.
All right, always a pleasure. Take care. Have a good
You as
afternoon.
well.
All right.
Position number 33, Mr. Matthews.
Okay, Mr.
Mhm.
Matthews, I'm hearing that this is a bond hearing. Is that still correct?
Your Honor, after speaking with Mr. Matthews, he has agreed to take the negotiated plea with one exception. If we could ask the state to not place a stay away order or ask for a stay away order, as the stay away is set for Mr. Matthews' home that he leases. His name is on the lease. He pays for insurance there. And if the state can remove the stay away order, Mr. Matthews will accept the plea.
Why don't you, well, I don't really want all this discussion necessarily on the record. So,
We as a state, we could agree to that, Your Honor. And
okay.
we can modify the contact to no further violent contact per the
Okay.
victim's wishes.
Okay. All right, Mr. Matthews, your case is 25 CR 002961E. Your case, in this case, you're charged with simple battery, family violence, and battery against a pregnant female, as well as criminal trespass. Do you understand your rights this morning? All right. Ms. Harrison, will you give me the state's recommendation?
Yes, Your Honor. The state's recommendation for count 1, simple battery, family violence, is count 1 will merge with count 2, which is battery, family violence, first offense. The state's recommendation on count 2 is 12 months, serve 180 days, credit for time served, 17 days. The defendant has been incarcerated since May 25th. The balance will be probated, completion of a family violence intervention program, 40 hours of community service, no further violent contact with Mariah Munoz, and as I said, we'll modify the stay away. So count 3 is battery against a pregnant female will merge with count 2, and count 4, the trespass, will be 12 months probation concurrent with count 1. We ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea, and we'll sound for the victim in case Ms. Munoz has joined us in court today. That'll be all.
Is Ms. Munoz present, wishes to make a statement? Okay, counsel, do you stipulate to those elements, and was that your understanding, and you wish to move forward with the plea?
Yes, defense stipulates that is our understanding.
All right, Mr. Matthews, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. Are you under the influence of any drugs or alcohol at this time? Did anyone force you to take a plea today? Did anyone promise you anything in exchange for taking a plea? And you understand that taking a guilty plea, you give up your right to trial by judge or by jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt? And you understand that taking a guilty plea may affect other aspects of your life, such as employment, probation, immigration, or other things that I may not be able to anticipate?
Yes.
And you fully understand that this is not a time served plea, that you have additional time to serve in the Fulton County Jail?
Yes.
And you understand the other requirements as explained to you by your attorney, including the fact that you'll have to take a class, complete 40 hours of community service, and you have no further violent contact with Ms. Munoz. You understand that? Is that a yes?
Yes.
All right, thank you. As for the charges previously listed in the case ending in 2961E, Mr. Matthews, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
No, Your Honor.
All right, best of luck to you, Mr. Matthews. That concludes your case.
Excuse me, Your Honor.
Yes.
This is the court reporter. Could I just have the name, please, of the attorney?
Yes, the public defender, attorney Mir Sajidin, that's MIRSAJEDIN.
Okay, thank you.
Thank you.
All right, who do we have next?
We can do position number 39, Mr. Randy.
Right.
I have that this is a negotiated plea. Is that still correct?
Yes, Judge.
Thank you. Mr. Rainey, your case is 25 CR 002964G. You're charged with criminal trespass. Do you understand your rights?
Yes.
All right, thank you. Ms. Harrison, please proceed.
Yes, Your Honor. In this case, the state of Georgia versus L. Rainey, case number 25CR002964G, criminal trespass, count 1. The state's recommendation is 12 months probation, served 60 days, credit for time served 17 days. The defendant has been incarcerated since May 25th. The balance will be probated. No contact at all with Alexis McCauley, and restitution to be determined within 30 days. We ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea. And we'll sound for Ms. McCauley in case she's joined us here in court today. That'll be all.
All right, Ms. McCauley present and wishes to make a brief statement? Okay, hearing and seeing none, counsel, do you stipulate to the 3 elements, and was that your understanding?
Yes, Judge, that is our understanding. We do stipulate.
All right, thank you. Mr. Rainey, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right. You can put your hand down. Are you under the influence of any drugs or alcohol at this time? Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand taking a guilty plea, you're giving up your right to trial by judge or by jury.
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes.
And you further understand that taking a guilty plea may affect other aspects of your life, such as employment, probation, or immigration.
Yes.
Are you satisfied with your attorney's representation?
Yes.
And you further understand the requirements as explained to you by your attorney?
Yes.
As to the charges of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea, Mr. Rainey. Is there anything additional from the state or from the defense?
No, Your Honor.
All right, best of luck to you, sir. That concludes your case. Who do we have next?
Position number 15, Mr. Hewley.
26, Hugh.
I'm sorry, 26, I'm sorry, 26.
Okay, thank you. And the announcement I have is that this is a negotiated plea as well.
Yes, that's correct, Judge.
All right, thank you, Mr. Hewley. Your case is 25CR003110E. In this case, you're charged with criminal trespass. Do you understand your rights today? Is that a yes?
Yes.
All right, thank you. Ms. Harrison?
Yes, Your Honor. In this case, the state's recommendation is for criminal trespass count 1 is 12 months probation, served 22 days, credit for time served 11 days. The defendant has been incarcerated since May 31st. The balance will be probated. A stay away from BP gas station located at 100 Lakewood Way Southwest. 40 hours of community service to be completed, and we're asking for a social worker visit prior to the defendant's release. We're also asking that the defendant stipulate to venue, ID, and facts of the case, and we also want to just notify the court that the defendant has a previous conviction for trespass at the same location, and that'll be all for the state, Your Honor.
All right, is there a social worker at the jail now he could speak to so that we're not holding his release necessarily for that?
No.
He'll be sent.
When is a social worker scheduled to come from your office?
You can have one come as soon as tomorrow, Your Honor.
Actually, today, Judge, we can get it done today. They normally will stop by.
Okay.
So
I just didn't want to hold him in for that if it was going to be longer than 24 hours or so. Okay, Mr. Higley, please raise your right hand. Do you swear or affirm testimony you give today be the truth to the best of your knowledge?
Yes.
All right, thank you. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
You can put your hand down. Thank you. Did anyone promise you anything in exchange for taking a plea?
No.
Do you fully understand the requirements of the sentence, including the community service you would have to complete, and the fact that you cannot go back to that location?
Yes.
Are you satisfied with your attorney's explanation of the impact of the sentence?
Yes.
And you fully understand that you're giving up your right to trial by judge or by jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
All right, as to the charge of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
No, Your Honor.
Your Honor, this is Kasha, the social worker. I spoke with Mr. Hewley at his first appearance already. There's no concern for competency right now. He is unhoused and he was already given resources.
Okay, so we'll say that the social worker visit aspect has been satisfied. Thank you, Ms. Williams.
Thank you.
All right, is there anything additional?
Nothing from defense, Your Honor.
All right, best of luck to you, sir. That concludes your case. Who do we have next?
Position add-on 1 and 2, Anthony Chalmers.
All right, do we have an announcement yet for that case?
Your Honor, I anticipate a plea, if I just emailed Ms. Falk. I don't know if that's satisfactory or not. If not, we can do a
Oh,
non-executive.
I think Ms. Falk, Ms. Falk is back. Your position is number, add-on 1 and 2 gonna be negotiated?
We're gonna go non-negotiated, Your Honor.
Okay, so let's see, Mr. Thomas, your case is 24 CR 004880J. You're charged with DUI less safe, and driving with a suspended registration. Do you understand your rights, Mr. Thomas?
Yes, ma'am.
All right, let's hear from pretrial, Ms. Washington. Can I have the history for add-on 1 and 2, since this is a non-negotiated plea?
Yes. There are 3 arrest cycles from the 90s out of Maryland. And in Georgia, there are 7 arrest cycles. There was a 2023 arrest for DUI out of Talbot County. It was an arrest for a DUI and driving while without a valid license. No disposition was listed. There was also an arrest in 2022 for a DUI with Atlanta Police Department. No disposition was listed on that case. There was a 2022 disposition for a misdemeanor conviction out of Talbot County for a DUI and driving while license suspended. There was also an arrest in 2020 for a DUI that was reduced to a non-fingerprintable charge out of Talbot County in 2022. And there was an arrest in 2010 out of Gwinnett County for a DUI that appeared to be no price. Nothing further.
There's a lot of DUIs in his history, Mr. Haddad. Okay, so I'm gonna ask, what is the point of contention between the state and the defense?
Judge, I'm sorry, Ms. Falk, do you want first, or?
No, feel free.
Judge, the issue in this case is my client has been in custody since March 5th in Muskogee County, Judge. I actually called the jail and confirmed he was in custody from March 5th on a DUI that he resolved and was transported, and the failure to appear was put on him as well when he got arrested in Muskogee. So he was in custody from March 5th up until he was transported to Fulton County Jail May 17th. So the state's recommendation, we don't have any issues with all the other conditions, Judge. I'm simply requesting, the state was recommending 90 days in custody with credit for 24, I believe. I'm requesting, and the 24 days are, I believe, from May 17th, and perhaps when he first got arrested back in 2022. But I'm essentially requesting, Judge, that once the failure to appear was placed on my client, that he gets credit for that time. So in other words, he's been in custody since March 6th. That's what I'm asking this time, sir. Those are the reasons, Judge.
Okay, so he was in Muskogee since March 6th, and Ms. Falk, you looked at that, and your position is because he wasn't booked in on
Well,
this charge?
Two things, Your Honor. One, I didn't look at anything because I didn't receive any documentation, which is what I did request. I understand that P. Haddad called them, but normally we do ask that some documentation be provided. So that was number one. And number two, yes, he wasn't booked into this jail on that charge. And so therefore, I can't give him credit for time served. The jail's not going to honor that without documentation.
Yeah,
So
I
it kind
agree.
of goes, it
Mr.
kind of goes
Haddad,
back
is
to
it-
the initial
yeah.
issue.
Is Mr. Haddad, is there something we can get to show that time? Because Ms. Falk is correct. They're not going to give him that credit unless we have something to document that he was serving somewhere else.
So unfortunately, Judge, Muskogee County does not have anything online, which I often will do. And Ms. Falk did suggest that I reset it for another week. Obviously my client is trying to get out, which is why I was trying to push this by at least calling. I mean, as an officer of the court, I can confirm that that's what they informed me.
Right, I understand, but I'm just concerned that even if we all do it, the jail is going to look and see that he doesn't have the credit, and he's not going to get out. So
Just reduce the jail time asked for.
we could, but
That's essentially what I'm asking for, Judge. I mean, we're not, I understand the court's concern. I know what the record says recommendation.
right, I get it. I get what you all are saying, but his history has so many DUIs that I'm inclined to go with the 90 days. I'm just being honest, but I don't have a problem with getting him the credit for the time if he's actually sat there, if we can prove that he's done it. And I understand what you're saying as well, Mr. Haddad, but
So
I get it. Let me think about this one for a second.
And
Okay.
Your Honor, if I can put the facts on the record on this case.
I mean, I don't think you have to. I mean, but you can if you'd like. Go ahead, Ms. Falk.
It's very brief. This happened on September 27th, 2022. It was a motor vehicle accident involving the defendant who was driving down Cascade. Well, a victim who was driving down Cascade and was struck by the defendant, which made his vehicle roll over due to the impact. The defendant was found to be 1.39 and 1.68 on the breathalyzer samples with the Intoxilyzer 9000.
I was not the cause.
And a bottle of Hartley VSOP was found in the vehicle.
Okay. What we're going to do is we're going to add this case onto Thursday to give Mr. Haddad some time to find the proof that he served that 90 days. And then am I here? No, I'm not working here on Thursday. Is it Judge Law? Let me look. And I will tell her about this particular matter. Okay. All right. So reset this case for this Thursday as an add-on. All right.
Thank you.
Thank you, Judge. Thank you, Mr. Hartman. So he can go back.
Oh, Ms. Champagne, you're gonna fuss at me? We can't reset it Thursday?
The attorney Emerson needs the contact number for the jail so he can speak to his client.
Oh, I didn't see that in the chat. Yes, is there a number that Ms. Attorney Remsen can call to speak to Mr. Hale?
Yes, he can call 404-612-2392.
All right, who do we have next?
Well, the last two we have are for conflicts, and the conflict attorney is not.
Yes, Ms. McLeod's here. She's here.
Okay, we can do a position 7 and 8, Bellamy.
Okay, Mr. Bellamy, your case is 25 CR 002705J. In that case, you're charged with theft by taking and loitering and prowling. You also have 25 CR 002717J. In that case, you're also charged with theft by taking 2 counts. Do you understand your rights this morning?
Yes, ma'am.
All right, Ms. McLeod, are these pleas today?
Your Honor, I haven't had the opportunity to speak with my clients yet.
Okay,
I'm just
and I know
logging on.
the phone is busy, I think. Is
Hold on,
there?
there's another phone available, I can call her.
Okay, they're gonna call you, Ms. McLeod. Thank you.
Thank you, Your Honor.
All right. And these are the last two. Let me see. This is the last two on our calendar today.
Yes, ma'am.
I'm
Okay,
looking for,
let me see. What about position 48? Bertha Williams, I had need to speak.
We will need to reset. It's a medical issue again.
Oh, reset medical?
Yes.
Hold on, Mr. Clark, don't go ahead.
Okay. All right, Ms. Champion, in the meantime, oh, I'm sorry, what about 45, Gary Weaver?
No, that's gonna be a not guilty.
Not guilty, you're gonna enter that, Mr. Haddad? Okay, thank you.
position 29 also to Judge Jones, Quinetta Jones.
Okay, let me see if I had an announcement for that. Somebody.
That's ACDC, Judge. That's gonna be a plea.
Is ACDC is online. Is there anyone at ACDC?
Don't see them, Judge.
They're on the screen, but it's dark.
ACDC, you can go ahead. They're ready.
I have a couple pleas from ACDC, Judge.
Yeah, she can still do her.
Okay, ACDC is not present yet. Okay, I guess we will be holding for a brief moment. I was gonna review the calendar, but can we call ACDC and see if they're coming?
Stand by, Your Honor.
Thank you.
Mr. Haddad,
Yeah, yes.
is position 32 a reset? Melvin Marshall?
Yes. Not reset, it's gonna not guilty.
I didn't hear you.
Not guilty, so it's a reset.
Okay.
That's been locked in there.
Mr. White, position 19 and 20, Mr. Kenneth George was released.
Yeah, this case was the
Thanks, Blunt. Got it.
Ms. McLeod, what's your announcement?
Your Honor, Mr. Burchett is going to be a negotiated plea, and Mr. Bellamy is going to be a non-negotiated plea.
Okay, so let's do the one that's negotiated first. Is this Mr. Burchett? Okay, so Mr. Burchett, your case is 25 CR 0029994E. In this case, you are charged with a offense I will not sound. Do you understand your rights this morning?
Yes.
All right, thank you. Ms. Falk?
Yes, Your Honor. On Mr. Burchett's case, the recommendation is 12 months, serve 32 days, credit for time served 16 days. That is from May 26, 2025 until today. Balance probated, 40 hours of community service, stay away from Creek Walk Connector. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
We do so stipulate, Your Honor.
That was your understanding.
Yes, Your Honor.
All right. I'm gonna place you on your oath. Mr. Burchett, please raise your right hand.
And Your Honor, I would ask if my client's probation could go non-reporting once he has completed all the provisions.
State has no objection.
All right, it can go non-reporting. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, Your Honor.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, Your Honor.
Are you satisfied with your attorney's representation?
Yes, Your Honor.
Did anyone force you to take a plea today?
No, Your Honor.
Did anyone promise you anything in exchange for taking the plea?
No, Your Honor.
And by taking the plea, you understand you're giving up your right to trial by judge or jury.
Yes, Your Honor.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes, Your Honor.
And you further understand that you're that taking a guilty plea may affect other aspects of your life, such as probation, employment, immigration, or things I may not be able to anticipate.
Yes, Your Honor.
And you fully understand the requirements as explained to you by your attorney.
Yes, Your Honor.
As the charge in the case ending in 2994E, Mr. Burchett, how do you plead?
Guilty.
I accept your guilty plea, and again, once he's completed the requirements, it can go non-reporting. Is there anything additional?
Nothing
right.
further, Your Honor.
All right, best of luck to you, sir. That concludes your case. All right, let's go to Mr. Bellamy. Mr. Bellamy, your case is 25 CR 002717J. In this case, you're charged with 2 counts of theft by taking. You also have 25 CR 002705J, in which you're charged with theft by taking and loitering and prowling. You understand your rights?
Yes, ma'am.
All right, can I have the history, Ms. Washington, for positions 7 and 8, Mr. Bellamy?
Yes, there are 6 arrest cycles with multi-state interaction in Georgia and in North Carolina. There's a 2019 misdemeanor conviction for injury to person out of North Carolina. A 2024 misdemeanor conviction for theft by shoplifting out of Rockdale County. The arrest was in 2022, 1 FTA in 2024 out of Rockdale County.
Okay, thank you. Ms. Falk?
Yes, Your Honor. And just to give you some background, the co-defendant on this case is Gira Davis, who also received the same recommendation from the state. This case, all of these cases happened on the property of Georgia Tech campus. On May 15th of 2025, officers got a report of a stolen scooter. They made contact with Benedict Vertuccio, who was a Georgia Tech student. He stated that he had secured his scooter to the bike rack, and he then found his scooter missing. The officers found both gentlemen at 964 Marietta Street, and Mr. Bellamy and Mr. Gira were riding on scooters that did not belong to them. One of the scooters was determined to be the one stolen from Mr. Vertuccio earlier that morning. And so that was the offense on that case. The other count of theft by taking involved the taking on May 15th of 2025 of a scooter. Let's see. My apologies, Your Honor. The other case involved an incident on April 17th of 2025. That involved officers responding to the Georgia Tech campus, talking to Fletcher Machada. Mr. Machada stated he was working on 14th Street at the IPST2 building. He parked his scooter on the southeast bike rack, and when he went back, it was gone. It was about $400. The officers did pull a video. They were able to see the defendant and Mr. Guerra ride up on a scooter, attempt to remove that scooter, attempt to remove a different scooter when unsuccessful, and then went and took Mr. Machada's scooter and then rode off using that scooter and the scooter they arrived on. The other charge was for theft by taking. That was involved Mr. Molly's scooter. That happened on April 18th. They received a report of a theft. Mr. Molly stated he had placed his scooter at the bike rack at IPST2 on 417. And upon his return, the scooter was missing. Again, the officers were able to capture footage of the defendant, Mr. Guerra, approaching the secured scooter, defeating the lock, securing the scooter, and then exiting the area. And that is the reason for the state's recommendation, which was 12 months served 90 days, credit for time served 27 days, balance probated, stay away from Georgia Tech, 40 hours of community service, and anti-theft course. No further contact with Mr. Machada, Mr. Molly, and Mr. Vertuccio. Restitution open for 30 days. Count 2, the loitering and prowling, 12 months concurrent with count 1. And on Mr. Bellamy's case, 12 months concurrent. On his position 8 case, 12 months concurrent with the previous case ending in 2705J. The state's recommendation, again, is due to the fact that this was a theft spree, essentially over over approximately a month's time, involved both of the defendants. The defendant has a prior conviction for theft by shoplifting here in Rockdale County in October of 2024, and not even a year later, he's running essentially a scooter theft ring with Mr. Guerra, which is why their recommendations were the exact same. We would like to sound for Mr. Machada, Mr. Molly, and Mr. Vertuccio. That's all for the state.
Are there any of those parties present and wish to make a statement? All right, Ms. McLeod?
Yes, Your Honor. My client has been in jail for the past 27 days. Of course, he was not in a position to post bond. That's why he has been sitting in jail. At the time he was arrested, and when I initially spoke with him, he expressed some major concerns because he had pets, that he didn't have anyone to take care of his pets, and just some other things going on in terms of his employment and his housing situation that he knew would have been negatively impacted by him being locked up. And I understand what the state is alleging, Your Honor, but I listened very carefully. And what they're saying is that someone else that he may have been with was seen riding off on the scooter. They did not see my client in possession of any stolen property at any time. So because that other person got that recommendation, it seems that there may certainly have been more culpability on the part of that other person. Your Honor, I do not think it is unreasonable for my client to be given just the 27 days because he really needs to get out. He has to pay, they want him to pay restitution and all that. He will not be able to do all of that without being out, getting his life back together, and trying to get some gainful employment. So I'm asking the court, we are okay with all the other terms of the plea. We're just asking if this could be the 27 days that he has already served, Your Honor, so that he could get out within the next 24 hours. That is all. That's the only way we want to deviate from what the state is proposing.
What was the additional time served under this, your recommendation, Ms. Paul?
They want 45 days, Your Honor. We are asking for 27.
Okay.
Well, he served 27 so far of the 45 he would need to serve. So less than 20 days remaining.
Less than how many days? I'm sorry, Ms. Falk.
Less than 20 days remaining, Your Honor.
Yeah. All right. If he takes the plea today, Ms. Falk, and Ms. McLeod, I am gonna accept the state's recommendation. He would have to serve the additional time. Does your client wish to move forward and take the plea?
Yes, Your Honor.
It does. All right, Mr. Bellamy, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
Yeah.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this
No,
time?
I'm not, no.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you are satisfied with Ms. McLeod's representation? Is that a yes?
Yeah, I guess so.
Is that it easy? It's not a guess, so yes or no?
No.
You said no? All right, let's ask it again. Are you satisfied with,
I'm sorry, what's the question again?
are you satisfied with your attorney's representation?
Oh, yes, ma'am, I am. Yes, ma'am.
Okay. You fully understand the requirements of the sentence, including the restitution you would have to pay, the additional time you have to serve in the Fulton County Jail, and the requirements upon your release as explained to you by your attorney?
My attorney said I had to finish 12 more days. I'm trying to be clear on that. That's what she said.
Let's calculate it. Ms. McLeod, do you, or Ms. Fault, let's get the exact number of days you have to serve. I'm never good at this. Let's see. I'm trying to calculate it myself. I'm never good at this.
I think it's 17 days, Your Honor.
Okay, I got 18, but I don't go by myself. My math is not good. All right, so I believe it's 17 days. Do you understand you have an additional 17 days to serve in Fulton County Jail? And do you wish to move forward taking the plea, Mr. Bellamy?
Well, she told me 12 days. That's what she told me. It was 12.
My math is terrible. I apologize. It's 27 you've already served, and they wanted to serve 45.
So do you wish to move forward and take the plea today? Is that a yes?
Yes, ma'am.
All right. And you understand that taking a guilty plea can affect other aspects of your life, such as employment, probation, or immigration?
Yes, ma'am.
All right. As to the charges listed in the case ending in 2705J, Mr. Bellamy, how do you plead?
Guilty.
And as to the charges listed in case ending in 2717J, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional from the state or from the defense?
No, Your Honor.
All right, Ms. McLeod, does that conclude your business today?
Yes, Your Honor, it does.
Take care. Have a good afternoon.
Thank you. You too.
Okay, bye-bye. All right, what positions do we have at ACDC?
Morning, Your Honor. We have position 4, 28, 29, and 47.
All right. Who would we like to take first? I'm fine with either of them, any of them.
Position 4, Anderson, Bridget Anderson.
All right, all defendants at ACDC, please pay attention. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. As you can see, I am conducting this hearing by video. It's being recorded and broadcast over the internet as a live stream. When I ask if you understand your rights, that is what I'm referring to. Ms. Anderson, your case is 25 CR 002704E. You're charged with 3 counts of simple battery. Do you understand your rights? All right. When you speak, please speak as loudly as possible. Thank you. I have that this is a negotiated plea. Is that still correct?
It is, Judge.
All right, Ms. Falk, please proceed.
Yes, Your Honor. State's recommendation on count 1 of simple battery is 12 months served, 90 days, credit for time served, 26 days. From May 16th, 2025 until today, balance probated, stay away from Mary Mac's Tea Room located at 224 Ponce de Leon Avenue, Northeast in Atlanta, 40 hours of community service, 12 weeks anger management, no further contact with Constance Perdue, Thomas Miller, and Dimitri Fowler. Counts 2 and 3 will be 12 months served, 90 days, credit for time served, 26 days to run concurrent with count 1. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. We would at this time like to sound for Constance Perdue, Thomas Miller, and Dimitri Fowler.
All right, do you so stipulate, Mr. Haddad?
We stipulate, Judge.
And that was your understanding?
It is.
All right. Are any of those parties present as listed by the state? All right. Ms. Anderson, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury? Is that a yes?
Yes.
All right, thank you. Put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange?
No.
Are you satisfied with your attorney's representation?
Yes.
And you understand that you're giving up your right to trial by judge or by jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt? And you further understand the requirements fully, including the fact that you cannot go back to the Mary Max Tea Room location? You understand that?
Yes.
And you fully understand the requirements as explained to you by your attorney? I just want to make sure you understand. Is that a yes?
Yes.
All right. As to the charges previously listed, Ms. Anderson, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
No, Your Honor.
No, Judge. Thank you.
All right. Best of luck to you, ma'am. That concludes your case. All right. Who do we have next?
I do have a question. They said that I would get 10 days in probation. Oh, so what do I have to serve? 10 days? They said I would get out in 10 days.
Not 19 additional days, 18 or 19.
How much?
18 days.
And then I'll get out, be released.
Yes.
Okay, thank you.
All right. Have a good day, Ms. Anderson.
Position 28, Jenkins, Tawana Jenkins.
Ms. Jenkins? Oh.
Reset. I'm not.
Okay, we don't need Ms. Jenkins today.
It's
That case is reset to next week. Your attorney has some additional work to do, Ms. Jenkins, and someone will come and speak to you, okay?
Next
All
is
right.
position 29, Quinetta Jones.
All right, I have the this is a negotiated plea, is that correct?
That is correct, Judge.
Okay, Ms. Jones, your case is 25 CR 002713B. You're charged with simple assault, criminal trespass, 2 counts of committing certain prohibited acts in a bus or rail station, and terroristic threats. Do you understand your rights? All right, thank you. Ms. Harrison?
Yes, Your Honor. The state's recommendation for count 1, simple assault, is 12 months probation, served 54 days, credit for time served 27 days. The defendant has been incarcerated since May 15th. The balance will be probated, no contact with Rhonda Allen, stay away from all martyr property, 40 hours of community service. We'd like a BHET completed and 12 weeks of anger management. Count 2, criminal trespass, will be 12 months probation, served 54 days, credit for time served 27 days. The defendant has been incarcerated since May 15th. The balance will be suspended, stay away from all martyr property, and it'll be concurrent with count 1. Count 3 will merge with count 2. That's certain prohibited acts at the bus or rail station. Count 4 will merge with count 2 as well. And count 5, the terroristic acts and threats, will merge with count 1. The state asks that the defendant stipulate to venue, ID, and facts of the case, and that will be all for the state, Your Honor.
I'm sorry, and the victim was Rhonda.
I'm sorry, yes, Rhonda Allen, and we'd like to sound for Ms. Allen.
All right, I'm sounding for Ms. Allen. Okay, and just making sure there was no additional jail time on this case, correct, Ms. Harrison?
By the math, it looks like that would be all of the jail time, Your Honor. You're
Okay,
correct.
making sure. All right, Ms. Jones. I'm sorry, Mr. Haddad, you stipulate, and that was your understanding?
Yes, Judge.
All right, Ms. Jones, I'm gonna ask you some questions to make sure you want to take a plea. Please raise your right hand. Do you swear or affirm the testimony you give today be true to the best of your knowledge?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time? Ms. Jones?
No, ma'am.
All right, are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
And you understand by taking the plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
Do you fully understand the requirements, including the community service, the anger management classes, and the evaluation you have to undergo?
Yes, ma'am.
And
Will I
you,
be released today? No,
if you, I'm sorry, I can't hear you.
I said, this means that I will be released today.
If you don't, go ahead, Mr. Haddad, you can explain.
It'll be later tonight or tomorrow morning. Depends on the jail.
Okay.
All right, you have to take, we haven't finished though. So you fully understand all the requirements upon release?
Yes, ma'am.
All right, as to the charges previously listed, Ms. Jones, how do you plead?
Guilty.
All right, is there anything additional from the state of defense? I accept Ms. Jones's plea.
No, Judge.
No, Your Honor.
All right, best of luck to you, Ms. Jones. If you don't have other holds, you should be, they're gonna start processing you out, okay?
Thank you, ma'am. All right. Next is position 47, Mr. Whiteside.
He's also.
That one's reset next week.
2 weeks, Judge. 2 weeks.
Oh, 2 weeks. My apologies. I had reset 6/17. That's not correct.
No, let me double check, Judge. I have one that's for next week and another one for 2 weeks from now.
Okay, I had 6/17, but either way, we're not. Mr. Whiteside's case will be addressed another day. Are there any other people at ACDC?
No, Your Honor. Thank you for everything.
All right, thank you. I think the one completed ACDC. Are there other parties at courtroom 2?
Your Honor, we still have, the client, Mr. Hale, positions 21 and 22.
The private case. Yes, I know we're holding on him. What about the, I'm sorry, there was another position I was looking at. What about the pro se individual? I think the last name was Hall.
Harris, Judge, I think, he went downtown, Judge. He has another case and they're both being handled downtown in front of.
Okay, so reset 1 week SAP.
Judge Richardson, I think.
Okay, what about position 23, Mr. Earl Hall?
Your Honor, that is gonna be a not guilty plea.
Okay, not guilty, reset, further notice. Okay. I think we're complete SAP other than Mr. Hale. Is there an announcement, Ms. Falk? And I don't see his attorney anymore. Oh, there, Mr. Remsen. What is the announcement for Mr. Hale?
We are trying to firm up negotiations, Your Honor.
Okay.
Mr. Remsen, we sent you the phone number for the jail so you can speak with your client, Mr. Hale. He's asking to speak with you.
Thank you so much.
All right, is the party present yet for the DP reset case? Is Mr. James Jackson here? And who's going to represent Mr. Jackson at that DV reset?
That'll be me, Your Honor. I do not see him.
I don't see him either. Okay.
Got another 5 or 6 minutes.
Yeah, I mean, we're early. I was just hoping we could do that. In the meantime, I think we've done everything else. Ms. Champion, can we at least review the calendar unless there are other announcements? Mr. Haddad, you had another announcement?
Yes, just for clarification, Judge, on Whiteside, Mr. Whiteside, position 47, I wanted to reset to the 24th.
Okay, so 2 weeks. That's fine. All right, thank you. All right, if Ms. Champion, you will review the calendar.
Position number 1, 2, and 3 will be reset to the SAP 626. Position number 4 was a plea. Position number 5 was a plea. Position number 6 is going to be reset for the notice. Position number 7 and 8 was a non-negotiated plea. Position number 9 was a plea. Position number 10 is reset for the notice. Position number 11 was a plea. Position 12 was a non-pros. Position 13 is reset to the SAP 617. Position number 14 was a plea. Position number 15 was a plea. Position number 16 was a plea. Position number 17 and 18 is going to be reset to the SAP 617. Position number 19 and 20 was non-pros. Position 21 and 22 we're holding on. Position 23 is reset further notice. Position 24 is going to be reset to the SAP on 6/17. Position 25 is going to be reset to the SAP on 6/19. Position 26 was a plea. Position 27 was a plea. Position 28 is going to be reset to the SAP on 6/17. Position 29 was a plea. Position 30 is going to be reset to the SAP on 6/17. Position 31 was a plea. Position 32 is reset further notice. Position 33 was a plea. Position 34 is reset further notice with an amended bond of $1,000 good bond. Position 35 was a plea. Position 36 and 37 is going to be reset further notice. Position 38 is going to be reset to the SAP on 6/19. Position 39 was a plea. Position 40 is reset further notice. Position 41 was a plea. Position 42 was a plea. Position 43 was a plea. 44 was non clause. Position 45 is reset further notice. Position 46 is reset to the SAP on 6/17. Position 47 is reset to the SAP on 6/24. Position 48 is reset to the SAP on 6/17. Add-on 1 and 2 will be reset to the add-on reset for SAP this Thursday on 6/12. Any questions?
Judge, one clarification, position number 38. Johnson Anua is gonna go on the competency calendar, Judge, next Thursday.
Is there an evaluation pending? If not, they can't go there.
Well, the problem is, we're gonna submit one since he's refused to come out. I mean, we've tried several times, so.
Okay.
So,
Makes sense.
well, actually, it would need to be reset 6/26. We don't have court on 6/19.
All right, we're not here. It's a holiday.
No, okay. I mean, my request to go on the competency, which is on a Thursday.
Right, but what we're saying is Thursday is fine, but there's no, the 6/19 Thursday, there's no court.
That's right. 6/26 is fine.
Okay.
All right, is there now an announcement on Mr. Hale?
I think we're pretty close, Judge. Maybe if I spoke to Ms. Falk for a second, we could do it a little more quickly, which I'm happy to call her.
Yes, that's fine. Now that I'm freed up, I'm willing to talk to you about it.
Thank you.
Okay.
And I put my cell in the messaging to you. If you want to
I
call me,
will
that's
give
fine.
you a call at your cell.
Okay, thank you so much.
I got money. Don't look like that, but I have been trying to AQ. I'm just saying. I already know. This case, 8 years old, like.
so then I'll just go back to the office and do the leave paperwork for the people.
Your Honor, may we be excused?
Yes, you may. Yes, you may.
All right, bye-bye.
But wait, are we completely done? I guess so. Yes, you all can be excused. If Ms. Greenhouse, if you would hold one moment, we're not quite done with you yet. Thank you
Mr. White is still on, obviously, for.
for the DV and for the last one. Yes, thank you.
Judge, are we ready for Mr. Hale? Hale?
All right, I am, I'm ready if his attorney and Ms. Falk are ready.
All right, okay, all right.
Hi, Your Honor, Mr. Remsen and I are finishing up. I am sending him the plea paperwork on this case, on both of his cases, so that we can resolve both of his cases today.
Okay.
And I do
That's
apologize
correct, Judge.
for the delay. We were trying to hammer out some last minute details.
That's fine. And has Mr.
And
James
Judge,
Jackson
that's
appeared?
all on me.
Hold on one second, Mr. Remsen. That's okay. Is Mr. James Jackson now present? All right, does he need to speak with you, Mr. White, or have you already spoken to him?
No, I need to speak with him, Judge.
Okay, can we put Mr. White in a breakout with the screen name that says Kim King, please?
Yes, ma'am.
All right, and whenever Mr. Remsen has the paperwork and has reviewed it, we can go ahead and do the plea.
Thank you, Judge. And actually, I just wanted to offer my apology. Miss Falk has been incredible. She's working out both of these incredibly old cases kind of on the fly with me. And it's certainly not her fault that this is delayed. I just want to clear that up. This is definitely I could have reached out to her yesterday and I didn't do that, Judge. And so I appreciate the court and her time this morning.
All right, you owe her a Snicker bar. How about that?
Hey.
All right, and I do see the age of these cases, so I'm glad you all are able to resolve them today.
Mr. Remsen, I just sent you the plea paperwork on both of your cases.
Thank you so much. Ms. Falk, logistics wise, do you know if I sign and I get permission from my client, is that acceptable, or do you know how the judge
That's
works on it?
acceptable.
Yes,
That's
that's fine.
acceptable.
Okay. All right,
That's
thank you.
acceptable as long as your client says that he has no objection to you signing.
And Ms. Champion and Judge Williams, I sent you the plea recommendations that Mr. Remsen and I agreed to with the modifications so that you have the updated plea.
Okay. Pulling it up now. Let's go ahead and talk to Mr. Hale. Mr. Hale, your cases are 20, I'm sorry, there's no 20, 17 CR 023161Y. In that case, you're charged with simple battery and simple assault, family violence. There was also 17 CR 02731 I'm sorry, let me do that again. 17 CR 027361Y. In that case, you were charged with obstruction, driving while your license was suspended, erratic lane change, speeding, and reckless driving. All these cases took place back in 2017. Do you understand your rights today? Is that a yes? I just need you to speak as loudly as possible. Oh, you're muted. That's why. Perhaps we can unmute him. There we go. All right. Thank you. Ms. Falk, if you're ready to give us a recommendation, we can proceed.
Yes, Your Honor. On position number 21, the simple battery, the state's recommendation is 12 months served 28 days, credit for time served 14 days. That will be from July 28th to July 29th of 2017 and May 30th of 2025 till today. Balance probated, no further contact with Arnethia Calhoun, Family Violence Intervention Program, and 40 hours of community service. Count 2 will merge with count 1. My understanding is that the defendant has completed back in 2017, after this incident occurred, he completed a domestic violence intervention program. The state will agree to have him, if he submits the certificate on that of completion, that will complete his conditions of FVIP on that case. Position 22 on the willful obstruction, 12 months concurrent with count 5 and a $300 fine. Driving while license suspended, count 2, we're amending to no license on person. I will send that amended accusation upon the conclusion of this case. That will be 12 months concurrent with count 5 and a $265 fine. Counts 3 and counts 4, we will null pros, and count 5 will be 12 months served 36 days, credit for time served 18 days. That will be from December 7th to December 12th of 2017 and May 30th of 2025 until today. Balance probated and a $1,000 fine. We are deleting the 40 hours of community service. That will be completed on position number 21. We are also agreeing to a NOLO as to the reckless driving on and on to as for the willful obstruction on position 22.
Okay, so he's doing NOLO for 22 and 21. He's pleading guilty.
Correct. And we will ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Before we do that, what's the total number of fines on position 22? I had
it will be 13. It will be $1,565 of fines on position number 22.
Okay. All right, I'm sorry, Mr. Remsen. Go ahead. You so stipulate?
We stipulate to the factual basis for sure, Your Honor. And I think what my client may be asking about is the service of the days, which, forgive me, I didn't mention to him that he gets the 2-for-1 credit. So it's credit for time served, released on time served as far as he's concerned. That's my understanding. And if that's not correct, please correct me.
That is correct.
That's my calculation as well. He would be credit for time served.
Yes.
Perfect. Thank you, Judge.
Unless he has
And
any holds or outstanding warrants, he should be released in the next 24 hours.
All right, so let's go through the plea colloquy to make sure this is voluntary. Mr. Hale, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to plead guilty today?
No, ma'am.
Did anyone promise you anything in exchange for pleading guilty?
No, ma'am.
And pleading guilty, you understand you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you further understand that taking guilty pleas may affect other aspects of your life, including probation, immigration, employment, or other things I may not be able to anticipate?
Yes, ma'am.
And you further understand all the requirements explained to you by your attorney, including the fines that you have to pay, the course you are responsible for, and the community service and all the other requirements we've discussed previously?
Yes, ma'am.
All right, as to the charges in the case ending in 3161Y, how do you plead, Mr. Hale?
Yes.
All right, and as to the charges of obstruction and reckless driving in the case of 27361Y, how do you plead there, Mr. Hale?
Yes.
No, that one you're gonna plead no low, so let's ask that again. In the case ending in 27361Y, how do you plead, Mr. Hale?
No, no.
I accept your no low plea. I accept your guilty plea as well. Is there anything additional from the state or from the defense as it pertains to these cases?
Your Honor, we are
No, Your Honor,
asking that
nothing
the,
from the state.
oh, excuse me. We're just
My
asking that the
apologies.
probation terminated upon completion. I don't believe the state had any objection to that when I mentioned it.
State has no objection to that once the conditions are completed.
Yeah, it can terminate upon completion. All right.
Okay.
All right. Best of luck to you, Mr. Hale. If you don't have other holds, you should be released and they'll start processing you out.
May I ask one more thing, Judge, while we have Mr. Hale?
Yes.
Mr. Hale, do I have your express permission to sign the plea paperwork?
Yes, sir. And can you call me?
Yes.
What, I'm sorry?
I said, yes, you do. And can you call me back real fast?
Oh, of course. Yeah. All right. And Your Honor, do I get that plea paperwork back to Ms. Falk?
You're gonna
first?
send it. Go ahead, Ms. Falk. You can explain.
Sorry, Your Honor. Yes, if you can send that to Miss Champion, I will send you her email address shortly.
Thank you so much.
Not a problem.
All right, Mr. Remsen, you can be excused. Take care. Have a good day. And I
Thank you.
believe state all purpose is now complete. We just need to do our DV reset case. And we can start that calendar now. All right, I'm gonna start the DV bench warrant calendar. This is State Court of Fulton County, Georgia. Again, I'm Judge Melanie Williams. This calendar, we will address cases where the individual now has a bench warrant for failing to appear in a domestic violence case. I don't know if there was an offer, I believe, Ms. Falk, was that sent to Mr. White?
It was, Your Honor.
And your client accepts or rejects that offer, Mr. White?
Your Honor, at this time, he's not willing to accept that offer.
Okay. All right, let's talk about the existing bench warrant then. Ms. Falk?
Yes, Your Honor. If you'll just give me one moment, I'm just sending to Mr. Remsen, Miss Champion's email address, and
Okay.
I'll be able to get back on track.
That's fine. And we'll also need you to just put that offer on the record for us as well.
Yes, Your Honor, I can do that as well. The state's recommendation on, let's see.
Oh, I'm sorry. Hold 1 second. Go ahead. That'll give you more time too, Ms. Falk. Mr. Jackson, your case is 23 CR 001079B. In this case, you were charged with battery family violence with the offense date of February the 24th of 2023. I'm going to advise you of your rights. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today, and Mr. White is present to represent you. As you can see, I am conducting this hearing today by video. I am not there in person with you. You're also appearing from a remote location. This particular proceeding is being broadcast over the internet as a live stream. It's being recorded as well. That means any member of the public can log on and watch this. Do you understand your rights, Mr. Jackson, and how I'm conducting the hearing today?
Yes, ma'am.
All right, thank you. And Ms. Falk, we're ready when you are. If you need another moment,
Yes,
that's
Your Honor.
fine.
To put the recommendation on the record, the state's recommendation is to this case was 12 months to serve 6 days, credit for time served 3 days from February 24th to February 26th of 2023, balance probated, FEIP and ADET, non-reporting after completion and no further contact with Tashawn Watts. The defendant, it looks like his bond order was forfeited on on December 4th of 2024. He was given a bond on February 25th of 2023, bond amount in the amount of $2,500. And we do have a return to sender on December 3rd of 2024, where that notice was returned. So that is the information just to let the court know on the bond and how it came to be forfeited.
Okay. And the state's position regarding setting aside a bond in light of the return to sender?
I would like to inquire as to the request for the lifting of the bond. There may be a very reasonable explanation to why it was returned to sender, but if it's because the defendant failed to update his address, then the state would ask that the bond revocation, that the bench warrant be enforced.
Okay, Mr. White, do you have any information regarding that?
Yes, Your Honor, quite a bit of information. First, he did show up to his plea arraignment calendar, and there was a misunderstanding between his public defender in division. He said, "You're good to go," and told him to leave. And after, for doing that for 20 years, I'm sure he was explaining that you're good for today. We're just waiving your arraignment. You don't have to come back. But that's not the way Mr. Jackson understood it. In the meantime, his home was destroyed. I believe it was demolished. And therefore, he did not receive the notice. But he did not change his address because he didn't think there was any more court to come. He's actually at the office of his bonding company right now. So he couldn't get the technology, so he had to go there. So he's in touch with his bonding company. We do have a new address for him to send any notice to, and this is the only time that he's missed court on this case. He also has a co-signer, his daughter, who he's in contact with, and the bonding company's in contact with. I've explained to him that his case is not over. He will have to appear in court a couple more times at least. So we just ask that you set aside the warrant.
Okay, I'm inclined to set it aside. I'll let the state lodge any additional objections.
Actually, we went through his history, and although it is lengthy, there is about one FTA from back in the 90s. So we're not going to object.
Okay, we're going to set aside his bench warrant. Mr. Jackson, make sure you update your address with the court. Make sure you stay in contact with everyone else. Be aware that this is still pending and open, as Mr. White just explained to you, okay?
And Judge, I have the address. If we can go ahead, I can go ahead and give it to Ms. Champion if she wants it, or
Ms. Champion, can you update it, or does he have to come and update it himself? I can't hear you, Ms. Champion.
I can put it in the chat for me.
I can do that.
All right.
Judge, briefly, I do believe Ms. King of A Rapid Bonding Company would like to address you. So.
Okay, Ms. King.
Hi, Your Honor. This case is well over 2 years old, and because of Mr. Jackson's age and his health, I'm wanting to know, is there any way possible we can come off the bond now at this point and just let him do a signature bond for himself?
There'd have to be a full motion, and that goes to a different calendar. I couldn't address it today.
Okay, because we had, if you look in his file, we had wrote the court for that. And I appeared, I went scheduled to appear. He was supposed to come to court last week for the forfeiture, and I showed up, but they did not have court that day. And I had to have Ms. Smith a whole lot of us showed up to come to court that day for his forfeiture hearing because we had requested to come off the bond if we could. And I thought I was going to address it that day, and they had to reschedule the whole day. And that's how I ended up
Yeah.
getting to come in.
It'll have to go back to that same calendar you were originally scheduled for. Okay.
Okay, well, they never rescheduled it. They just told us.
They will. They will.
Okay. So
I
they'll,
will.
okay, okay.
Yes, ma'am. All right.
Thank you, Your Honor.
All right. You're welcome. Take care.
Are we,
All right.
are we done for today's?
We are, and I believe our entire calendar is complete as well. Take care, everyone. See some of you all this afternoon. Have a good one.
Thank you.
Ms.
Bye-bye.
Champion, did you see my email in regards to my message? I put it in the chat. Ms.
I'm sorry,
Champion.
who are you asking, Ms.
Oh,
Falk?
Miss Champion.
Oh, okay.
Thanks, Miss Greenhouse.
Yes, ma'am, I did.
Oh, you did see it?
You asked for the calendar?
Yes.
Okay, yes,
Okay, thank you.
ma'am.
Bye.